When it comes to occupational health and safety law, there are frequent changes and developments. But what's happening in Ontario OHS Law at this time? Lawyers Casey Caldwell and Jeremy Warning of Mathews Dinsdale Clark in Toronto share some updates.
Well, Bill 132 amended the Occupational Safety Act to include more detailed provisions relating to workplace harassment, including an amended definition of workplace harassment to include the concept of workplace sexual harassment. The amendments came into force on September the 8th of last year, so employers are expected to be fully compliant now. And what the Code of Practice that the Ministry released about a month prior to the compliance deadline does is sort of clarify the Ministry's approach to certain provisions that Bill 132 has amended, in particular what they expect by the way of the quality or timing of an investigation into an allegation of workplace harassment.
The criminal code was amended a few years back to create a duty on anyone who directs a worker to ensure that they take all reasonable steps to make sure that that worker and those performing work are safe. And if they don't, it could potentially ground a criminal negligence charge. We want to make sure that employers are aware of this possibility and how the courts have assessed this type of charge.
There is currently an appeal that's pending about the obligation to have internal people inspect the workplace and what constitutes the workplace, particularly for employers who have dispersed workforces such as postal carriers, courier companies, where they may have employees going to locations that are not directly controlled by the employer, and whether or not there is an obligation on that employer to inspect those workplaces or have them inspected by the Workplace Safety Committee. The only thing of relevance to all employers that we'll be dealing with is the Ministry of Labour releasing back in January a statement of their approach to the definition of a critical injury that may modify what employers understand the obligation to be, and therefore may mean that the Ministry is taking a different approach as to what constitutes a critical injury, and therefore what may obligate an employer to report an injury or hold the scene of an injury.
These are just a few of the areas of OHS law that are evolving. Be sure to stay up to date with the latest regulations, comply, and create a workplace that is safe for everyone. For Canadian Occupational Safety, I'm Alexia Capralos.